Welcome to this part 4 of Judge Johnston's interview. In this podcast, you will have the opportunity to hear about the role of a clinician in the Children's Court.
The clinicians are people who are provided by the Children's Court Clinic, which is an important resource in care proceedings. What it means is that the clinic maintains a list of specialist clinicians, which include psychiatrists, psychologists, and other specialists involved in child care, who can conduct clinical assessments of children and others such as parents and relatives. Clinicians observe the protagonists in the proceedings over a period of time, interview parents, children and others in detail and on different occasions, in neutral or non-threatening environments, away from the court and away from their lawyers, and so they are untrammelled by court formalities and processes, such that clinicians can provide the court with a number of insights and nuances that might not otherwise have come to the court's attention.
Why is a clinician's report crucial to the process, and how much weight does the court place on it in evidence?
Well, I believe that the clinician's assessments are of great assistance to the court and can derive considerable assistance from their reports. In addition to providing an expert opinion that's independent, the clinician can, as I said, provide a hybrid form of factual evidence not otherwise available in a court process. The clinician can provide impartial, independent, objective information that's not contained in other documents and can give context and detail to issues that others may not have picked up on. This sort of information is really helpful to the court, which otherwise just sees people in the formal environment of a court where they are on their best behaviour and sometimes constrained in the way they respond to questions.
Do you see the clinician's report as relevant to informing ongoing casework for the child?
Yes, I do. A report by a clinician can also inform and guide the ongoing casework for the child. For that reason, I would like to see these reports being made available more readily to NGO caseworkers after the court proceedings have concluded. Care does need to be taken, though, in some cases where, for example, the clinician's views have been criticised or discredited in the court proceedings, or in some cases even rejected. What I've suggested is that the reports could be redacted before release to omit or block out any sensitive material or controversial material, but leaving for the guidance of caseworkers the clinical evidence relating to the child and any particular therapeutic issues that might help the clinician in the ongoing management of the case.
In your paper, you mentioned conclaves and concurrent evidence, and that both of these techniques will be increasing in the Children's Court. Could you briefly explain what these are, please?
Yes, I think it's going to be increasingly the fact that in the future these sort of modern procedures for courts will be more and more used and useful. They're designed to simplify conflicts or factual conflicts or conflicts of opinion between experts. And these include, as you said, conclaves and concurrent evidence. The idea of a conclave is that the various experts, usually medical practitioners or caseworkers, have been involved in the treatment or assessment of a parent or a child, sit down before the hearing together in a room and try and reach agreement on as much as possible. What they can then do is identify only those matters on which they don't agree and leaving those matters for the court to decide. Sometimes this can lead to the preparation of a joint report, and if there is the less disagreement there is in relation to expert opinion, the more simple it is for the court to reach a resolution of a case. Concurrent evidence involves all the experts being in the witness box at the same time, rather than the traditional means of giving evidence in court one after another. The advantages of this include the ability to focus on one issue at a time with everybody there and having their say at the same time, and also the capacity for each expert to comment on the other expert's opinion and sometimes even to ask each other questions.
Is this unique to the Children's Court?
No, it's been happening in the Supreme Court for some time and in the District Court. It's not as common in the Children's Court as it is in those courts, but it's mainly a matter of the cost of doing so. But it's something that I think we'll increasingly see the court make use of, particularly the idea of a conclave before the final hearing.
That concludes Part 4 of Judge Johnston's interview. Part 5 will provide detail about Section 90 of the CARE Act.